items for delivery of order. Item number 1.
IA allowed. Bail order dated 29/6/2022 is 2022 stands cancelled. The respondents have to surrender forthwith before the Court of Learned. Session Judge Borpeta.
Item number 2, bail application 1105 of 24.
Petition dismissed. Oblige.
Item 3, bail application 765 of 2024. Item number 3, bail application 1065 of 2024.
Petition dismissed.
Number 4, bail application 1105 of 2024.
Petition dismissed.
Yeah, please, Your Worship. With regard to item number 10, my lord. Yes, there is no call for.
Worship, here final report submitted, Worship.
What is the final report number?
21/24, dated 20/03/24.
Dated
20/03/24.
what is the ground for filing the FR?
That is not mentioned, Worship.
So we close the matter.
Well,
We close the matter.
my lord, that's fine.
Probably it does matter. Item number 10. Yes. Next item.
From daily list for motion item number 5.
May I please, Your Lordship? An application under section 488 of KRPC Lordship. Yes, the allegation is 294, 323, 354, 379 Lordship. Kindly, and the FIR is page number 13 Lordship. One Sahida Khatun is lodged the FIR. And
So this is second bail application.
Earlier rejected by this honorable court.
So what is the ground for filing this second application?
Lordship, kindly, para 7, page number 4.
Yes.
We're going to say has come to know from relevant source that the police may have completed their investigation, Lordship. And
Pardon?
complete their investigation. At para 7.
Whether search sheet is submitted.
May possible, maybe, Lordship.
Pardon?
Some submit if search sheet is not submitted.
Not submitted.
It may be possible, Lordship. And GBS sustain
Okay,
GBS
let the city come then.
Worship.
Pardon, sir.
RLCT.
Learned counsel for the applicant and also her Ms. Andas, learned additional PP for the state respondent. The second application
28.
under section 438 services prepared by applicant Manjur Ahmed, who has been apprehending arrest in connection with Julia PS case number 69 of 2024 under section 294, 323, 384, 379 IPC for grant of pre-arrest bail. Having heard the submission of learned advocates of both sides, it is provided that Ms. Das shall produce the case diary before this court on
On 28, Lordship. 28.
Item for admission, item number 6.
Meet with the Lordship.
Yes.
Lordship, on the last occasion, Dr. Sugar asked me whether 397 is a supervisory power of the High Court. Documents produced before this court. 17.4 is the most important. If the evidence which the prosecutor proposes to adduce to prove the guilt of the accused, that means as per the 161 statements, even if fully accepted before it is challenged in cross-examination or rebutted by the defense evidence, if any cannot show that the accused committed the offense, then there will be no sufficient ground for proceeding with the trial. This is only on the basis of the materials on record as per 173, the documents given in 173. 17.5, it is open to the accused to explain away the materials giving rise to grave suspicion. 17.6, the court has to consider the broad probabilities, the total effect of the evidence and the
No,
documents produced before this court.
You see, these guidelines are mainly for the trial courts.
No, my lord, it's for discharge.
Yes,
is for
who will
discharge.
discharge?
Discharge, against discharge, I'm coming in revision.
You are coming into revision.
Same thing, my lord, against discharge, this is the order that I'm challenging. High Court will,
These guidelines mainly for the trial court.
I will just give this, relying on this judgment,
Hmm.
this honorable court has actually discharged me, not this honorable court, Supreme Court has, regarding on this case, relying on that, Supreme Court has discharged. If your lordship takes, if I may pass out, this was a case where we had appeared, charges were framed under 302, 201, 120B. High Court has dismissed our petition.
In another case, perhaps same strength of benches stated that reappreciation of evidence in a revisional jurisdiction not permissible.
Yes, my lord, not permissible.
Hmm.
I am not saying reappreciation. The what 17.4 says, even if you take it on the face value without there being cross-examination,
Hmm.
has anything been made out? And there are certain judgments of 306 where the mens rea of the accused has to be shown. His positive intent has to be shown. My lord, in this next case, I'm going to rely. This was 302, 120B, 201 was framed.
Hmm.
High Court this honorable High Court has dismissed it. Supreme Court, relying on the 2020 judgment, had said motive cannot be made out from the 161 statements, and Supreme Court discharged me. I'm passing on these two judgments, my lord. My lord, the 2021 SCC online 2629. That's the High Court judgment. Your lordship comes to paragraph 9 of that judgment. Last page. After hearing the grounded counsel for the parties, this court is of the opinion that at this stage, any conclusion with regard to the guilt or innocence of the accused revisionist cannot be drawn, as the role of the accused revisionist in the alleged act of causing disappearance of evidence will depend upon examination of the witnesses before the trial court and their cross-examination by the defense. Under section 227 of the Code of Criminal Procedure, only prima facie satisfaction of the court is required. Based on this, the revision petition was dismissed. This was challenged before the Supreme Court. Now, the Supreme Court judgment is of 2022 SCC online SC 967. Your lordship comes to paragraph 10 of that judgment, of the Supreme Court judgment. Paragraph 10 relies on that same earlier 2020 judgment that I had just now placed, the 17.1 to 17.8. It quotes it, paragraph 10. Paragraph 11, if your lordship takes up. Paragraph 11, taking into consideration the aforesaid legal principles, if we consider the facts of the present case, it reveals from the perusal of charge sheet and other materials available on record that the investigating officer had not brought even prima facie material in the charge sheet as to what the motive on the part of the appellant to commit the offense. This was only on the materials available on record, the police papers that were available. Trial had not yet started. If your lordship then comes to paragraph 15, there is no iota of evidence which in any manner connect the present appellant with the commission of the crime, and neither the trial court nor the high court has even taken pains to look into the record as to whether there is any oral documentary evidence which any manner connect the appellant with the alleged incident of crime. And in our considered view, in the absence of even a prima facie material oral documentary being placed by the prosecution in the charge sheet, the trial court as well as high court has committed serious error in framing charge against the appellant. This was petition under 397-401. Then my lord, my earlier judgment that I have placed on that date, 2010-12 SCC. I placed on the last occasion, 2010-12 SCC 190. Your lordship comes to paragraph 22. But 21 is also same, 21. The learned counsel for the appellant has placed reliance on so and so judgment. He has quoted the judgment part. Thereafter, the court.
Oh, where is the finding of the court?
My lord, finding of the court. Finding is at page 25, my lord. Sorry, paragraph 25. Abatement involves a mental process of instigating a person or intentionally aiding a person in doing of a thing. Without a positive act on the part of the accused to instigate or aid in the committing of suicide, conviction cannot be sustained. The intention of the legislature and the ratio of the cases decided by this court is clear that in order to convict a person under section 306 IPC, there has to be clear mens rea to commit the offense. It also requires an active act or direct act which led the deceased to commit suicide, seeing no option that the act must have been intended to push the deceased into such a position that he committed suicide. Paragraph 27. When we carefully scrutinize the critically examine the facts of this case in the light of the settled legal position, the conclusion becomes obvious that no conviction can be really sustained without any credible evidence or material on record against the appellant. The order of framing charge under section 306 against the appellant is palpably erroneous and unsustainable. These are the cases of discharge. And on same lines, I will place two other judgments.
Not necessary.
Just one order, my lord. One order. This is small judgment. Why mere harassment? Our case says that I have been harassing her. Why allegation of mere harassment does not bring the ingredients of abatement under 107? This is a small Supreme Court order, my lord. The only problem with this order is there's no paragraph number. My lord, in this case, there was a suicide note where the respondents were named. If your lordship comes to the second page, the paragraph starting from learned counsel for the petitioner. That's the first paragraph. Learned counsel for the petitioner submitted that the High Court committed an error in allowing the revision petition, especially after 10 witnesses have already been examined. He referred to the suicide notes that were written by the deceased Firoz Khan to support his submission that Firoz was harassed by respondent numbers 2 to 4, due to which he took his life. There was a suicide note. He argued that abatement of offense of suicide by respondent numbers 2 to 4 is prima facie made out in the harassment by respondent number 2 to 4, facilitating the act of suicide by the deceased. This is important. In order to bring a case within the provisions of section 306 IPC, there must be a case of suicide. And in the commission of the said offense, the person who is said to have abetted the commission of suicide must have played an active role by an act of instigating or by doing a certain act to facilitate the commission of suicide. Mere harassment without any positive action on the part of the accused proximate to the time of offense which led to the suicide would not amount to an offense under 306 IPC. Next paragraph. Abatement by a person is when a person instigates another to do something. Instigation can be inferred where the accused had, by his acts or omission, created such circumstance that the deceased was left with no option except to commit suicide. In the instance case, the allegations against 2 and 4 is that they harassed the deceased. There is no material on record which indicate abatement. High Court did not commit any error in allowing the criminal revision. My lord, in this case, there was a suicide note. My case, the father and the wife mother says, we doubt that our daughter committed suicide because of the accused. They doubt. Their mother's statement that there were some viral videos being circulated. She says, we heard a rumor that viral videos are being circulated. No investigation to that effect. Nothing has been brought on the record. They have seized my phone. They had the girl's phone. They could have easily done it. After taking cognizance, now they cannot do anything. Then comes, father says, just before her death, I was talking to her. He thinks I was talking to her. CDR was not collected. Even if CDR is collected, the phones are, I've talked to her. Where is the instigation? Where is the material on record to show that I have instigated?
The question is whether sitting in revision, this court can go into such.
My lord, these are all
Sure.
judgments of revision I have placed.
Mm.
And all the judgments are of discharge and revision. There's nothing I have placed on which are for acquittal.
Mm.
In fact, my lord, the 2020 judgment, that's a PC Act case. PC Act case. There, what has happened? The accused had come up with a document on his own. Court had said that only because the accused document, we cannot look. In revision court, we cannot look at the accused document. That can go for trial. But otherwise, everything is materials on record. The 207 papers, does it make out a case against me? And in 306 cases, it is the offense is under 107 basically. Abatement has to be shown. Abatement has 3 criteria. I do not fall in the second and third. If your lordship takes up 107 IPC, I do not even fall in it. And 107 IPC, abatement of a thing.
That is there, but we have to clarify the legal position.
And a legal position I have placed before
one
your lordship.
judgment, I will see. Let us keep the matter pending for today. I will examine the matter thereafter. Again, I will hear you.
My simple submission, I have all the judgments that I have placed.
Furnish a copy to him
Yeah.
also.
Yeah, I'll give the side. None of them are for acquittal. All are discharge matters.
Mm.
All are cases where Supreme Court has interfered because charges were framed.
Mm.
None of the judgments that I have placed is for acquittal.
Mm.
And situations where there is suicide note naming somebody, even that is not abatement. Here to there is nothing. They are assuming that it was because of me she has committed suicide.
No, going by the definition of 107, definitely there must be some positive act.
Exactly, my lord.
So-
I do not fall. 107 has 3 parts. I do not fall on the second and third part.
Mm.
Only first part, whether I have instigated her.
Heard Mr. D.K. Bhattacharya, learned counsel for the petition, and Mr. T. Deuri, learned counsel for the respondent number 2, and Madam N. Das, learned additional PB for the state respondent number 1. Heard in part, recessal is the matter on after 1 week. 3-0.
Deeply obliged.
Obliged.
Bail hearing, item number 7.
Mayor, please. On 439 application, petitioner has been shown arrest in this case around 22/3/24. Today, my lord, 54 days he is behind the bar.
CD not received, lordship.
For how many days?
54 days,
54 days.
my lord. On last together, my lord.
What was the offense?
My lord,
Offense?
my lord, FIR is at face, my lord, 7 and XR 1. My name has not been mentioned in the FIR, my lord. Only one Eleanor Khatun, like Modul Islam and Muhammad Ali. These 2 persons have occupied the land of the informant, my lord. I am none of these persons.
Madam, where from the city will come?
My lord, it is from Bookstore PS, my lord. On last occasion, he was
Bookstore.
here, my lord. And the Lanet PP submitted before lordship.
On the other day, CD was available.
Yes, my lord.
What
Lordship,
happened?
then
Basit?
I have to
Huh?
verify in office, lordship. They have said.
But
not said-
on that day, we have not disposed of the matter on the fact that CDR was not available with the CD.
Yes, sir.
lordship.
So
And
find out the
tomorrow,
CD
lordship?
Huh?
Tomorrow?
tomorrow.
Lordship.
If we allow you time, then this mandatory period of detention will
Well,
work.
54 days, my lord.
Hmm?
He's get the bar.
Anyway,
I have to-
we'll give you the last chance.
Lordship.
Yes,
Earlier
and the-
case, my lord, he is on bail. Earlier he was arrested on 22, my lord.
Okay.
In that case, he has been
Allah-
released on bail. my lord.
Learned additional PP submits that she has not received the case, no, she has not received the case ID. But it appears from the record that it appears from the order dated 14/5/2024 that the case ID was available on that day and the same could not be produced on account of non-availability of CDR of the mobile phone of the accused. Accordingly, it is provided that accordingly, last opportunity is afforded to Ms. Das to produce the case ID before this court tomorrow.
Item number 8,
Wait, please, your lordship, lordship, this is 429 bail.
Here also, Lordship, I have talked with the IO, last chance was given, Lordship, they want one last time, Lordship.
Lordship, already lordship, on the last day's order, lordship, can you produce lordship? There's a
24.
co-accused already granted bail
So how
because of
many days you are behind the bar?
lordship 48 days today, lordship, shown arrested in this case, lordship, second time. And co-accused released on medical ground. I am also paying for on medical ground. My father is suffering from cancer, lordship. I've annexed all those documents, lordship. Co-accused bail order that is on page 54, lordship.
Initially, I have lost FIR lordship. But today,
Pardon?
lordship, if the honorable court will consider, I have no objection as the accused is my some relative lordship. Otherwise,
no objection.
allegation is serious lordship.
You have no objection.
Yes, lordship.
No, your stand is contradictory. Having said that offenses are serious in nature, and then stating that you have no objection, what is this?
May I please, your lordship?
So whether case diary was called for,
City receipt, Lordship,
city received.
Lordship in 164 statement, Lordship implicated, Lordship. Any queries, Lordship?
164 statement recorded.
Yes, Lordship.
Yes, so what is your submission?
My lordship, the petitioner and the informant, this is the second bail application.